So, what do you got? What do you got for me this week? Anything I can talk about?
Well, I got the county's motion to dismiss, and I just responded to it, so that's going on.
Okay.
Um, I cannot find one of the defendants, even though she's a defendant in your case.
You
I can't
haven't.
find her to serve.
Who is it? Which defendant?
Mary Sheehy.
Who? Say it again.
Her name is Mary Sheehy.
Mary Sheehy. So she's San Diego, and San Diego would not take service.
They took service for everybody but her, saying they couldn't get a hold of her.
Let me see if I have a proof of service on her at a home address. Hold on. It's taking a second to load here.
Okay.
But, yeah, if I have a proof of service for her on a home address as opposed to a waiver by the county, I have absolutely zero problem sharing that with you.
Thank you. I appreciate that.
And
Been a little bit frustrating.
yeah, I get it. I get it. Let's see. Pleadings, complaint, POS summon serve, Samuels, Sheehy, open. And let's see what we got. Mary Sheehy. Do you have a pen handy?
I do.
Okay, it's 1174
Uh-huh.
Old Janal Road, Janal,
Okay.
Chula Vista,
Chula Vista. Okay.
California 91915.
That's where I sent the waiver of service to, that same address. And it
Uh,
didn't come back.
yeah,
So,
she won't send it back to you. Let me give you my process server. He nails his target every time. His name is
awesome.
his name is Tim Wing, Wing,
Okay.
and his phone number is 619 993 9464. And I can tell you, I use him on hard service. Hard service being where the fuckers are dodging me, and he gets his mark every single time. In fact, I'll tell you a little story. I had a case against this guy named Jim Franklin, total crook, total fraudster. He had ripped off a bunch of shareholders. The SEC was trying to serve him, and they couldn't get him, and I needed to serve him, and fucking Tim Wing nailed his ass for me. And the SEC was like following all the filings, and they saw me file the proof of service, and they're all, "How the hell did you get this guy?" And I said, "Call Mr. Wing." And so he ended up somehow figuring out when the guy was going to be flying in on a flight from overseas, went to the airport, and since he knew him already because he had served him for me, he knew what he looked like, and just freaking waited for the guy. And then when he got off his plane, he nailed him with the SEC papers. And so yeah, Tim gets his man, every single time. So he's a good guy for, doing hard
Right,
service.
Tim. Still have to serve San Diego County, too, because they require in-person service. So.
Yeah, Tim can do that. He knows where to drop the stuff off. It's not a big deal. He's not horribly expensive. It's like $75 or $80, and he'll
That's affordable.
Yeah, he'll get everybody for you. Even the people that are dodging, he'll figure them out. He actually likes doing the hard service because it, gives him some challenging stuff.
I don't think Mary Sheehy's going to be that hard. She just isn't really cooperating.
Yeah, probably because she doesn't like being sued. That would be
well, this is her second now in 2 years. So,
Yeah, I mean, she must be doing something wrong, right?
You would think so, or else you wouldn't be sued for the same thing twice by two completely unrelated people.
Yeah, you would think. Yeah. full on correct. All right, cool. So we got you taken care of. Anybody else? How about NB? That must be Nigel Bliss, I'm guessing, but I'm not sure.
Yeah, can you hear me?
Yeah, I got you. How you doing, man?
Doing great. We had order on our order and judgment on the motion to dismiss in our case, and a lot of our claims are going forward.
Oh, awesome, man. So you got a clean sweep.
Yeah, there's a couple of areas, mostly Monell, failure to intervene, and alleging more state actor stuff that we got to shore up, but that'll be for the first amended complaint.
All right, cool. Right on, man. So they gave you leave to amend on your Monell claim?
Yeah, yep.
All right, and the other claims didn't get dismissed at all, or got dismissed?
Nothing got. Well, yeah, so things would get dismissed, but with leave to amend.
Yeah.
Cool. And so yeah, we have like malicious prosecution, wrongful use of civil procedure for the entire like DHS cases.
Now on your malicious prosecution, were you criminally charged?
Yep.
Oh.
And all
okay.
charges were dismissed.
Oh, okay, shit. Well, you got a solid claim then. Yeah, that was going to be one of the issues out here. What state are you in? I don't remember.
Oregon.
Oregon, yeah, okay. In California, the juvenile dependency proceedings very rarely are coupled with a criminal proceeding, and the juvenile proceedings in and of themselves are civil in nature. So, a 1983 claim for malicious prosecution will not lie. That's only going to be viable against a criminal action. So, yeah, I didn't.
Yeah, so the judge ruled that for both myself and my wife, we have state wrongful use of civil procedure, like, malicious prosecution analog for the civil case.
Uh-huh.
And that encompasses a federal due process 1983 action. So basically 14th Amendment tied to wrongful use of civil procedure.
Interesting. Would you mind emailing me your order?
You can look it up right now. It's the case is just Bliss versus Adewusi.
Oh, is it on like Westlaw or
you can
something?
Google it.
Or?
Yeah.
Oh, shit.
It just pops up.
Sweet. Let me look. Hold on a second. Let's see what we got here. Bliss v. What was the defendant?
Adewusi. That's ADEWUSI.
Adewusi.
She's a child abuse pediatrician.
That's quite the name. Open. Child abuse pediatrician, so called, right? Those people. All right, nice, cool, man. I'll download this. I'll read this later.
And so we have things, like warrantless removal for the children, and then a lot of fabrication of evidence. Essentially, we're trying to shore up Monell, failure to intervene, and state actors for the private parties. And we did use the NL versus Children's Hospital.
Oh, nice.
Case, and the judge cited that, but he used that only for the proposition that after the children were removed and in DHS custody, then when they coordinate like a forensic exam after the fact, they're state actor. And
oh, nice. That's nice. That's really not what NL stood for. NL stood for when a private medical care provider, or actually any private party, contracts with government to perform, traditional government services, then, they can be a state actor. But it's not.
Yeah, they have contracts as well.
Okay. So just for everybody that's going to listen to the recording later, I pulled up your case. I've got it up on the screen right now. You guys can't see it, but on the screen record, they will be able to see it. And basically what I'm looking at here, you were able to find attorneys to represent you up there in Oregon. Is that right?
That's correct.
Okay.
And they're aware that I'm speaking to you
Okay.
intermittently, but not for legal advice purposes.
Right, good. But what I wanted to do, if it's okay for you, is just sort of, let everybody know who those guys are. Because I get a lot of calls up in Oregon, but, I'm not admitted there. And I have a lot of family up there, actually. And if you know where Cave Junction is, we've got still the family ranches up there. But, yeah, I don't practice up there, but I do get a lot of calls from Oregon. And I normally send him to Michael Miller out of Bend, but I've heard that he's really not doing this stuff anymore. So I would like to
Yeah,
be able to send people to the guys that are helping you.
this might be their first. I think this is their first case, at least suing DHS. They have done malicious prosecution cases before, and then they primarily focus on. Yeah, I guess I would say like victims' rights or government accountability, right? So it is up their alley. I do have a feeling that after going through the motion practice and after doing these cases, they might have more interest in it. But
Well, they're gonna learn a lot, and it'd be a pity to waste all that education on never taking another one of these cases. So I think what I'm gonna do, with their permission or not, is I'm going to start referring people to these guys because I have nobody in Oregon to send people to that I think is reliable right now. And
yeah,
I get a lot of, a lot of calls, and it's like, oh, okay, well, I'd love to help you, but I've got no place to put you, no place to send you. And
so briefly, one thing that you mentioned a minute ago, with California, my understanding is the sort of juvenile dependency cases and the criminal cases. There's like a firewall between them where you can't really sort of communicate.
No, that's not what I intended to convey at all. There's on the prosecution side,
Mhm.
there is no firewall whatsoever. In fact, what those guys will do is say the prosecutor will criminally charge the husband, and the wife's not going to talk. Right? There's marital communication privilege, all kinds of stuff. So the wife's not going to talk. So what they'll do is they'll go over to social services and say, "Hey, go interview mom, and if she's not cooperative, tell her you're going to take the kids." And then social services will share whatever they get. I mean, mom's now got a gun to her head, right? You're going to cooperate with social services investigation, or you're going to be tied up in juvie court fighting for your kids. So mom then will talk, and then social services immediately will pass whatever information they get to the prosecutor. So on their side, there is no firewall whatsoever. But and they use it. They'll leverage that relationship to do things that are really, in my view, pretty improper. But that's what happens.
Yeah, that's kind of the basis of our wrongful use of civil procedure claim is that we had a DHS case open. They had state custody of the children for 3 years, and for
Holy
two
shit!
and a half plus years, the only thing they were waiting for is the outcome of the criminal case.
That's
Just entirely
crazy.
improper. So as soon as the like Brady evidence came out and the criminal case got dismissed within a week, the DHS case got dismissed. I mean, just
Wow! Holy
completely
crap! So
improper use of.
where were the kids for those 3 years?
They were with my wife for about 2.5 of them. So in
Okay.
home plan with the mom.
Okay.
I had supervised visits, and they just would not drop the case because they wanted. Our opinion was that they wanted custody purely to support the criminal prosecution.
So were you and mom like separated, divorced? What was that?
Oh, we're together. I was living with a family member or
So
living in my
they
car, Miss Lane.
so they took you out of the home.
Yeah.
Oh wow.
Had a
Damn.
criminal case through a no contact order on me.
Damn. Damn. Well, you guys have a good case. I'll follow this. This will be interesting. See where this goes. I think that it sounds like a good case. It sounds like you're going to get some traction on it. I'll read this opinion later and let you know what I think.
I don't want to take up too much of your time or other people's times, but so I think I asked you in the past where sort of, I know that conspiracy, you usually don't allege that, and you just kind of say that people were like the moving force of each act, or
Well, moving force relates more to causation. In fact, that's what it is. It's the and it comes into play in a Monell claim specifically, is that the unconstitutional policies, practices, or lack of training, supervision, that sort of thing. It was that deficiency that was the
that's
moving
right.
force that caused the social workers to violate your rights. That's the basic idea behind moving force. So it's really a causation issue. For conspiracy, you got to remember under 1983, and you can pick this up in the model jury instructions or form jury instructions on the Ninth Circuit website. They actually provide you a lot of case law and analysis, to sort of support what they think the jury instruction should look like. But what you're going to learn there when you read particularly the jury instruction for supervisory liability or co-tortfeasor liability is that they have to do more than just sort of know about it and talk about it. There has to be, like for a supervisor, there has to be direct involvement, like either through analysis, ratification, and approval, right? That would work. So, for example, on a warrantless seizure, and I don't know how they do it up there in Oregon, but just to use California as an example, the social worker will get assigned a referral by her supervisor. They'll talk a little bit about the referral before the social workers sent out into the field to investigate, and they'll sort of come up with a, if-then type plan. Okay, that's not enough to get liability yet. So then the social worker goes out into the field. She does her investigation. She says, holy shit, I think that I should just grab this kid. She's required to call her supervisor, tell the supervisor everything that she's discovered in her investigation, and then sort of discuss, okay, what do we do here? And then the supervisor is going to make the determination. Okay, we go get a warrant, we file a non-detained petition, or just grab the kid. That's enough. The supervisor giving the direction to grab the kid, that's going to be enough to pull the supervisor in for supervisory liability. So I guess in a sense, just kind of noodling through that, it's kind of like conspiracy, but it's not really. It's actually direct supervisor liability. So what I would suggest is get on the Ninth Circuit website and look at their model jury instructions under 42 U.S.C. section 1983 for supervisory liability, and that'll give you a pretty clear picture of what you're looking at.
Okay, and then for failure to intervene, you had a case on that that you posted a while back.
Probably Jill Randall. Kind of the lead case, if I remember correctly, is Boyd versus Benton, B-O-Y-D v. Benton, B-E-N-T-O-N. And then there's a whole bunch of cases that sort of dovetail off of that. And what you'll want to do is probably shepherdize it, kind of march it forward, because I'm sure there's been significant development in the law since the last time I was involved in one of those things. But what we use that for, and it's difficult when you're doing cross-agency. The most common place where you'll see failure to intervene, failure to intercede, is where you have, cops. And the classic example is, there's a bunch of cops standing outside the window. They're going to breach. Somebody makes the decision to throw in a flashbang. It ends up landing in the baby's crib and kills the baby. Right? Well, they're all going to be fucking liable for that. Right? That's the failure to intervene, failure to intercede. They shouldn't have done it. They have policies, practices, procedures they're supposed to follow. Some cowboy just went off the reservation, but nobody stopped him. Right? And then also another good example is like the Rodney King. I don't know if you remember that, the Rodney King
Right.
beating down in LA. You have 10 cops standing around watching a few cops beat the crap out of this guy. Well, they've got a duty to intervene and intercede and stop the brutality, right? Where you get into trouble. I found a few cases. I found one with Border Patrol and I think DEA or something like that. I don't remember. I'll have to look again. But where you get into trouble with it is cross agency duties. Like, say you have cops coming out to a home with social workers, right? Well, the cop is going to stand back and sort of defer to the social worker because the social worker is supposedly the subject matter expert there. And the problem I had pursuing those types of claims against the cops for not intervening is that they're not the subject matter experts, and typically they're out there just to keep the peace if shit goes down. And at least down here, the federal district courts are not really willing to go cross agency and say, okay, well, the cops had a duty to stop the social workers from taking the kids. You know, that's a really tough row to hoe. But I don't know if that's the situation that you're looking at in your case or not, but that's just been my experience, is that those are hard to make stick.
Yeah, there's quite a few underlying constitutional violations, like like the warrantless removal or like fabricated evidence, and so we're going to be using failure to intervene on quite a few various acts, and yeah, some of it is cross agency.
Yeah, the cross agency, I think you're probably going to have trouble with it. Interagency, like one social worker to another, a supervisor to a worker, that's just going to be standard, standard failure to intervene analysis because it's interagency and they're all sort of tied together. Same with the cops. If the cops interagency, within their agency were doing things and like a supervisor, sergeant, whatever, knew what was going on and should have stopped it or should have intervened. Yeah, that's just standard analysis. But I think you're going to have trouble doing cop to social worker or social worker to cop.
All right.
So you got anything else on that, or is that pretty much exhaust it?
There'll always be more, but I'll chew on this for a little bit.
Okay, cool. Anybody else? I think Michelle, you were on early.
The only other thing I wanted to talk about was the county's motion to dismiss. How unprofessional it was. They used 2 overruled cases. Miscited one of the statutes.
That's standard.
And used like 11 cases as precedent.
Yeah. That's standard for these guys down here. Who's your attorney that's opposing you?
Talia Edelman or something like that. Yeah. Alex. They put like
Talia
attorneys on my case.
Yeah,
apparently I missed.
Talia's fairly new. She's been around. She's actually really nice. I've got a couple cases with her right now. The one you want to watch out for is.
I don't know who wrote this though. It was Claudia something that wrote this.
Claudia, let me look.
Claudia or something.
Yeah, hold on. I've got. No, that's Miyamoto. Which one do I have Talia on? Let's see. I think it's in Pope. Yeah, in fact, I know it's in Pope. And who does she work with? I know the name Claudia, and I don't remember her last name, but I don't think that she's actually, like the shot caller. I think that Talia is actually going to be the shot caller on your case. What happened?
I don't think Talia wrote any of this stuff. It was other people that did. Let me look and see.
They do that all the time, though. They'll cite overruled cases. They'll miscite cases. You actually have to look very, very carefully.
Well, I went through everything because I wanted to understand their argument. They didn't cite. They didn't have complete citations. It was just. It was
really
bad.
They're really sloppy. They're really sloppy.
I was surprised. I thought it was more professional than it was.
Yeah, you have some sort of echo or feedback on your mic. Yeah, is it Claudia Silva? Is that who you're talking about?
That's it. Yep.
Yeah, Claudia Silva. She didn't actually write it. She is the head county counsel downtown. So her name's gonna appear on all of the filings.
Okay.
There should be 2 attorneys though listed in your caption. I
It
don't.
is. It's Talia Tillman and Alexa Katz.
Oh, I don't have anything with Alexa. I know Donnie Cox has stuff with Alexa, but I don't have anything with her.
Oh, okay. Well, I don't think, at least I can't see that she had anything to do with most of this stuff, but
Yeah,
don't know.
probably the one that wrote it is Talia, and I'll tell you right now, she's overworked. She has a lot
yeah.
of stuff going on. I think just with me, I've got shit. I think 4 cases with her.
Wow.
Yeah, so she's
So they must
under.
put her on everything.
Say it again.
I said they must put her on everything.
Well, there's what, 3 or 4 of them. There's Vishali Rogan, but she's on maternity leave. There was Kate Jones, but she transferred over to some employment section, so she's gone. She's the best one they had down there, so it was actually good that she moved on to somewhere else, some other division. That's good for us.
Good for us.
Yeah, but then there's Jeff Miyamoto and Alexa. So they have 4 that do these juvenile dependency civil rights cases, and I guess
Okay.
yeah, and they always team them. There will always be 2 county counsel on any case, or at least 2 county counsel on any case.
Well, I think they were hoping that the judge would dismiss my case sua sponte, but she didn't, which is surprising to me.
Who was your judge? I've forgotten.
Kathy Benchavenko or something like that.
Benchavenko. Yeah, Benchavenko. Well, she got reversed. She got reversed in part and affirmed in part in Benavides, and that was fairly recent. So she may be paying pretty close attention. So you made it through then on your motion to dismiss. You made it through. Or
I'm still waiting. It'll get to the court tomorrow, and it'll be filed probably the next day.
Okay.
And then on November 20th, we have a hearing about it.
Okay, got it. Well, keep us posted on how that goes. That'll be interesting.
Really super nervous about that. I've never been in a hearing like this before, so.
Oh, well,
it'll be fine.
It'll work out. You'll be fine. Just maintain your mental calm. That's the key.
Right. Well, as far as I can tell, no other pro se litigants have made it this far, so.
Yeah, well, that's a big deal, right? They don't like pro se litigants. They have to help you in federal court anyway. They have to help you, but they don't like you.
No, they're definitely not excited about it. That's for sure. But
Yeah.
they didn't get a sua sponte dismissal, so I think that's a good sign.
Yeah, totally. That's totally a good sign. So, what do we have here? I think EM. You were here early as well. You got any issues, questions, anything, whatever? Looks like hearing crickets. So, anybody else? We'll just open it up. Anybody got anything for me this week?
I do.
All right, what you got?
Well, first thing, Michelle, can you send me over, or can you put your case number in the chat? I'd love to go ahead and kind of follow your case to see how that's going.
Sure, I could do that. I'm not sure how to do that exactly, though. What do I click on?
You're using a computer. So do you see on the versus office hours?
Yeah.
You see the little chat guy, right? That little chat button on that same section? It's like a little chat bubble.
I don't see anything like that. I'm on a computer, not on a phone or anything.
Let's see on mine. If you hover over the, where is it?
Top of the screen.
Yeah, top of the screen, right hand side. A bunch of stuff will pop up.
Oh yeah, I see that.
And the little chat bubble's there too. If you click on it, it'll.
That's where it is on mine. Okay.
Awesome. So that was.
In my computer.
Yeah, I'd love to go ahead and follow that one to see how it's going. I've been following a lot of the pro se cases. So while that's happening, so Sean, I had a question. I've been watching the Take Care Maya trials,
Uh-huh.
and the defendants they're up right now, and what I'm noticing is they're using a lot of the depositions that the plaintiff did. Is that common to kind of, or use the other side's, um,
What do
the
you
other side?
what do you mean the defendants are using the depositions the plaintiff did?
Yeah, so for example, like in your case, you're doing the depositions with the social workers or whoever else is involved. Well, the defendants are essentially using yours, not yours per se, but the plaintiff's depositions that they did to to present their case.
The plaintiff's deposition of the defendants or the plaintiff's deposition of third parties?
The defendants.
Yeah, see that would never fly here and not in California. You can't your deposition is like a self-serving statement, right? It's only admissible for any purpose by the other side. It could be admissible by the defendant themselves, like as a prior consistent sworn statement, but only snippets, not the whole thing, or to refresh recollection if there's been some intervening thing that happened between the time the deposition was taken and the time of trial, and people just forget, maybe got a brain injury or something. So refreshment of recollection. You can always use it for rehabilitation, right? It's a prior sworn consistent statement. But normally the defendant isn't going to be able to use their own deposition in lieu of live testimony at trial. That's like only a one-way deal by an adverse party, at least in California.
Right. I've never heard of that being a thing, so I kind of got really confused by that, and I thought I'd ask.
Yeah, somebody
Um,
should be objecting to that and be filing motions on that. Is that in federal court or state court?
it's state court.
Oh, see, it's going to be whatever, and it's Florida
Yep,
or something, right?
they're Florida. Mm-hmm.
Yeah, so you got to look at Florida civil trial procedure and see what the rules
Okay,
are. Or actually, it's
got
probably
it.
in the discover. Well, I don't know what their discovery code is, whether they have something similar to our Discovery Act or not. But it's in the Discovery Act in California. It specifically lays out what you're allowed to use the depot for, and then you go look at the evidence code, California evidence code, to see the mechanism, like how you do it.
Got it. Okay. And then so another question I had, we kind of touched on this question before in one of the prior videos about the children's claims, how it's kind of different than the adult ones would be.
Mm-hmm.
What different claims would be, or what claims would be most common for the children?
That's going to depend on what type of case it is. If you're looking at most of the work we used to do before, like modern day, like now, would be a warrantless seizure, warrantless medical exam, warrantless medical procedure, or judicial deception, right? And that's all going to be for the parents. That's normally. Well, you got to remember that the children have an equal corollary right under all the same rules. So if you lied about my mom to get an order to take me away from my mom, I still have a judicial deception claim against you, even though you weren't lying about me, you were lying about my mom, because that familial relationship, think of it as an umbilical cord that runs between me and mom. All right, this magical, like, invisible cord that just connects us. If you cut it for her by lying, you've necessarily cut it for me as well, right? So you're going to have the same claims. It's going to be a judicial deception claim, a warrantless seizure. If they did medical examinations on me, I have a right to have my parents be involved in medical decision making, to be present at my medical procedures, to be involved in the decision making. And the moment that you sever that or interfere with that for my parent, you've necessarily also done the same thing with respect to my rights. So, that's the issue. Somebody who just came on, you need to mute your mic because we're getting feedback. So that's basically how it works. I got a little distracted, but did that answer your question more or less?
For the most part, I think you were saying something more so about how the specific claims in the children's case kind of matter more to them, or they apply. Maybe I'll have to go and find the video to kind of have that question better. So I guess I'll move on to the next one, which is
let me back up a little bit, because I'm trying to think what I've talked about before, why we sever the parents' claims from the children's claims, and there's a couple reasons for that. One, obviously, is because there's a collateral estoppel potential. If you put all the parents, the children, everybody together in one suit, you get a bad decision out of a judge, that the children's claims are going to die with the parents. Where if you sever them because of the rules, you remember Lucido, I sent you, I think it was last week, probably last week and the week before. I think we had similar questions on both sessions, and Lucido was the answer. But that gives you, your 5 elements, and one of them is an identity of the parties. So if you sever the children from the parents and file the lawsuit just for the parents, there's not going to be any collateral estoppel impact against the kids if you lose the parents' claim. So that's another reason that you might file them separate. A third reason that we file them separate, and this is sort of the biggie, is that the county, they sort of do an actuarial calculation on these things when they figure out how much they're going to be willing to pay. And that number is not going to change whether you've got 10 kids in it with the parents or no kids in it with the parents. So essentially what that means is that you're going to devalue and discount the child's claim if you lump them all in together with the parents. So what we started doing probably 10 years ago, once I figured out what those fuckers were doing, is we just say, no, we're just going to sue for the parents now. The kids' statutes, there's no rush, because the kids' statute of limitation doesn't even start to run on their federal claims till they're 18. So we sever them. And we'll say, no, we'll sue for the parents. And invariably at the mediations or settlement conferences, the counties will come in and they say, well, we want to pull the kids in and lump them in, and say, no, we're not going to do it. We've got one case, that's the parents, and you either want to settle it or not. If not, okay, fine, roll the dice, let's see where it goes. And invariably they'll resolve it. Now, we don't always come back immediately with the kids, life intervenes or things happen, but I'd say probably 60% of the time we'll come back again later and file again on the kids, and then we will get maximal value for the kids' claims instead of the discounted value. What other reason? Kids are always innocent. That's another good reason to do the kids separately. It's not the kids that are causing the problem. It's always a conflict between the worker and the parent. And sometimes the parents have a lot of baggage, and we don't want to muck up the kid's claim with the parents' baggage, where if the kid's coming in alone, they're really kind of innocent. It's a kid. They didn't do anything. So those are the reasons, the motivations that we might have for severing the parents from the children. I'm not sure what else I would have talked about.
not so much the severing of it. There was claims, something to do with the state claims. I was asking something about why it would matter if one claim won or if multiple claims won, and how the difference really makes in the outcome of the case. And you said that it really doesn't matter, except on children's cases. That's where it could get a little bit different.
I don't remember. I mean, as far as the different claims, those don't really impact your damages, right? I mean, it's basically the one cause of action rule. As long as it all arises from the same core set of operative facts, you're only going to be entitled to recover once for the same injury, right? So if you have 10 different causes of action, but the injury was an interference with your parental rights, it's the same injury, you're not going to get to recover 10 times just because you have 10 claims, if that makes sense. As far as the rest of it, I don't really know what that would have been.
Got it. Like, so for example, failure to provide minimally adequate care to the children, will that make any difference on an additional claim? Or maybe that's kind of where we're going with that?
I'm sorry, say it again.
So using that example, would then maybe the failure to provide minimally adequate care to the child while removed, would that be like a totally separate one that would be in a
Totally
Okay.
separate. Totally separate. That's something that's not going to be a claim that's going to impact the parent. The parent doesn't even have standing. Well, I mean, if they have custody, they have standing, obviously, to sue on behalf of the child. but the parent doesn't have an independent claim of their own arising from the failure to give adequate care to the child during the term of their dependency. That's going to be
Right.
the child's claim alone.
Okay.
Yeah.
And so as far as filing the government tort on that one, for the children, it would be within 6 months after the returning home. Is that, or after the case closes? Is that correct?
Well, it's going to be after the case closes, because remember, in this, there's actually specific government code provision for it. I don't remember the code section, but it's in the practice guide. While the child is under the care of the county, in the county's custody or under the county's supervision, their statute is told with regard to the filing their notice of tort claim. So even though, for example, the kid may be reposed back with the parent pending a 6-month review and hopefully a dismissal, the child's still a dependent of the court, right? Even though they've been sent back home. So until that case is closed and the dependency is dismissed, I think the statute on the notice of government tort claim requirement, that's still told.
Got it. Okay, and then so within the filing of the government tort, then it would need to be filed with the court within 6 months for the child?
Well, once you file your
For
tort
the state
claim,
claims.
yeah, for your state claims, once you serve your notice of tort claim on the county, they've got 45 days to respond to it. Actually, they have 20 days if they're going to inform you of any defects. Otherwise, defects on the face of the claim are going to be waived. Then they have 45 days to accept or reject the claim. I've never had one that was accepted ever. I mean, ever. So you can pretty much count on either a formal rejection where they'll send you a letter, or that if that 45-day window passes and they don't respond, then it's deemed denied as a matter of law. And then you have 6 months from the either formal denial or deemed denial within which to file your lawsuit. Does that make sense? So you have 6
Yes.
months, 6 months to serve your notice of tort claim once the kids are back. Then you have 6 months once it's rejected to file your lawsuit.
Got it.
Yeah.
So those are my questions for the week.
Okay, cool. Well, thank you. Decker Dog, you're up next. I hope they're still there. I saw in a comment that once you were done with your questions, they had questions.
Yep. I'm here. Sorry. So I had a couple of things because you were talking to NB about the cross agency, like the failure to intervene.
Yeah.
Now, what if it was a situation like where LAPD acted on their own, where the CSW was like not officially acting as an agent in the capacity as an agent, but they still had a badge?
I'm
So
not understanding the factual setup. So
okay, so if a CSW a person, say a person related in the family was also a CSW and abducted a child, and then during the course of the search for a missing child, like where helicopters overhead, bloodhounds going through the neighborhood, we're talking a missing child, that was discovered that the family member had the child, but they also had a DCFS badge. And so LAPD then deceived the parent and went and then arrested the child, putting them for neglect.
Wait, how old's the child?
10.
So what do you mean they arrested the child?
They placed the child under arrest because the child had been abducted and removed from the county.
Do you mean they?
And so when
I don't understand the arrest of the child. If they recovered the child and turned the child over to CPS, that's not an arrest.
Well, no, there's a booking report. They actually placed the child under arrest and then returned him to the county and booked him, and then released him to Children's Services.
Okay. Okay, so they gave him over to CPS, and then CPS did what?
detained them. But well, there had been, again, this is which, well, it kind of leads into my second question, which was more the well, I have a couple questions, but as far as like the continuing wrongs, you know, where there's a continuing violation doctrine, and then also a theory of continuous accrual, which I understand has like different results, but when you with the a conspiracy claim, I mean, because I understand that most of the time in these cases you're talking about the conspiracy claims as far as like the moving force of cause or causation. And to get,
We talked about that earlier. Conspiracy doesn't have anything to do with moving force. Moving force is a concept of causation that really only
okay,
comes into play in a Monell type claim.
okay, that explains it. I was like, wait, I
Yeah.
figured that it was just okay. I missed the differentiation.
Yeah.
Um,
Yeah.
then what about elements of conspiracy? I mean, where you know, again, if one of the actors is actually also a county agent and really working behind the scenes, and
I don't know. That's the factual setup sounds kind of weird. I don't think that you're going to have any liability on the cops, right? Because
okay, in that one, yeah, really,
their primary duty the moment they've got a missing kid is to go find the kid. When they find the kid, there's a social worker with the kid, a county worker with the kid, and they just book the kid, do their documentation, and turn him back over to the
well,
county.
right, but the when the child was missing, when the child was found, in fact, it was, you know, Orange County Sheriff said like, well, we aren't going to bring him up to LA, and LAPD said we aren't going to go get him.
Mm-hmm.
And the parents, of course, said, well, of course I can go pick up my child, but do not leave them with you know, obviously don't leave them with the person that has abducted them,
Mm-hmm.
even though they have a county badge,
Mm-hmm.
and yet that county badge weighed more than the parent. So whereas the parent drove down to Orange County to get the child as was agreed to, and as
So
she arrived down to
what was the basis for the removal?
uh uh for what, for the when the police removed her,
Yeah.
or just in general?
Well,
Well, it was
start with
neglect.
the
What he got
cops.
booked, what the child got booked on was neglect.
Okay. And what was the basis for neglect?
Unknown. That's
So
it's never been
so they didn't make any allegations at all, just said the child's neglected.
yep,
Okay, that's the cops, and then the cops handed the child over to social workers, right?
yes.
Okay, hold on a second.
And then but lied in their reports, which obviously, which the deceit is pretty apparent, because yeah, the police would not just like abandon a missing child investigation or search.
Hold on one second. I'm looking for something. Okay, look up Welfare and Institutions Code Section 309.
Uh-huh.
And that basically lays out in detail for you what's supposed to happen with the social worker once the cops hand the child over to the agency. And I'll just, read it here for everybody that's here live for their benefit. It's 309A says, upon delivery to the social worker of a child who has been taken into temporary custody under this article, the social worker shall immediately investigate the circumstances of the child and the facts surrounding the child's being taken into custody, and attempt to maintain the child with the child's family through the provision of services. The social worker shall immediately release the child to the custody of the child's parent, guardian, Indian custodian, or relative, regardless of the parent, guardian, Indian, relative, blah, 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 immigration status, unless one or more of the following conditions exist. And there's a bunch of gobbledygook in here, and then it ultimately gets to the question of essentially exigency, right? Unless there's an exigent circumstance that would put the kid in danger, they got to give the child back to the parent, guardian, or relative. So
I think one of those is if the child refuses to return.
not by statute.
Oh, it's not in there? Okay.
No, not not at all. So
Well, I think it's in one of the other statutes. Like there's I know there's something in the statutes in Welfare and Institutions Code that says unless the child is refusing to return home.
it's a 10-year-old kid. I don't think the child has a choice until, and I don't remember it's 12 or 14, but there's an age cutoff.
Right. Well, yeah, but that's what they have it listed, and
Well,
it's
what I'm telling you is I would take a look and focus my efforts. If I was looking at a litigation question, I would probably not be focused on the cops necessarily.
yeah, not at all.
If the cops came into your home and took the kid, that's one thing. Obviously, that starts looking like a warrantless seizure. But if the child's with a relative, and there's like a he said she said thing going on between grandma and mom or whatever, I don't think the cops need to really get involved in it. They're not the subject matter experts. It's probably going to be okay for them to just call social services and say, hey guys, I got this kid. Welfare and Institutions Code Section 309 says I can give you this kid. Here's the kid. You go figure it out. And
Right.
that's what it sounds like the cops did here. Now, the social workers, what they're supposed to do once the cops deliver the child, that's set out very clearly in WIC 309. So that is where I would focus my attention.
Yeah, well, I mean, there was already another seizure in addition to that. Like, so let me ask you about this. What about if a social worker does not have an active referral? So there's no referral.
Mm-hmm.
And yet they go to a child's school, like basically fishing to investigate, just start inquiring, asking teachers and staff, etc., if they can recall anything, that was ever said or blah, blah, blah. And then they call in, again, without a referral, they're there investigating though. And then they call in their own referral when like an after school coach remembered something from months earlier that was stated by a 12-year-old child, or actually 13 at the time, and uses that and then actually removes the child from school, and does just bring them home. But
I don't know. That's really convoluted, but I can tell you that social workers, during their investigation, if they turn up evidence of abuse or neglect, they're required to call in their own report. They have to call it into the hotline. So if talking to some coach at school, the coach said, oh yeah, Jenny had bruises on her leg and I think mom did it. Let's say that's the statement. The social worker, as a matter of law, since she's a mandated reporter now, has to call that in. So that's not
okay. Now, but what now? What about social workers going in to investigate when there's no active referral?
Yeah, there's something that caused them to go investigate. Maybe it was an old referral that they didn't finish closing out or something, but they don't.
No, the referrals, have been closed out, but it was
Yeah, they don't go investigate stuff for their health. They have way too much work.
Well, right. No, there was another social worker that was, when again, it's the same case. So when the grandmother's referrals were being what's it called, when they evaluate them out, so they started getting evaluated out, and so because she has access to the system, she then found out who had investigated the last referrals and started direct communication.
Yeah,
and under her and with her email, her county email.
Yeah, I don't know on that. Probably sue the grandmother. Probably sue the grandmother and sue the county. It sounds like she's doing it in her capacity as a county employee, a county social worker. So,
Oh well, yeah. She's done a lot more. I mean,
So, do you have any other questions? I'm not really here to give case specific advice.
Oh, okay, yeah.
Really
well, about the my question was about the element of conspiracy, where it's not just relating back to past reports or anything, but where it's actually this kind of, if a case came from kind of the top down. I mean, like where ARAs are calling other ARAs and saying, "Hey,
that's not conspiracy. That's going to be supervisory liability. That's not conspiracy. I mean, it's within the scope, the course and scope of their duties. That's what ARAs are supposed to do. I mean, if an issue comes up in the field and it can't get resolved by a supervisor, then we go up to the ARAs. Okay, guys, what do we do with this? You're the captains of the ship. I mean, that's
oh,
part of their
right,"
job.
but no,
That's
where
to
a captain of a
communicate.
ship out of Lakewood is calling a captain of the ship in Van Nuys, and
That may happen
Thanks.
as part of the investigatory process. That's what I'm saying. You need to go look at the law relating to direct supervisory liability, because that's how you're going to get them. You're not going to get them on a conspiracy.
okay,
Yeah, it's for 1983 claims anyway. For some state law claim, you might state law tort conspiracy. If you get an underlying tort like abuse of process, then you may be able to pull in other co-conspirators for that abuse of process. But for 1983 liability, you're not going to get it.
really, what if there's emails of county agents to uninvolved third parties instructing them to break and enter into a residence to get and providing all the confidential case information?
Well, who are the third parties? Are they law enforcement or are they private people?
Nope, private people.
Okay, so then you're going to sue those private people because they're acting at the behest of government, right? It's joint
Right.
action. It's joint action. So you're going to...
Okay, well, I mean, yeah, because conspiracy isn't really a claim on itself, right? It's not a separate
Right.
cause of action.
It's not.
It's just a basis for holding defendants liable for the harm done.
Yeah, you need to really do some deep research on how a conspiracy theory might apply in a 1983 case. There has to be direct involvement.
Yeah.
So that's what I would
Okay.
tell you on that. Anything else?
No, I think that does it.
Okay. What else do we have? Let me look at the comments. D.D. Cook. D.D. Cook, you there? You got anything?
I'm here and just still trying to listen and learn. So I don't
Okay.
really have any questions.
Okay. Okay, cool.
Just
Well,
thank you so much.
sounds good. Well, thanks for joining us. How about...
Thank you.
Sure, absolutely. How about EM? Oh, hey, we have a visitor with you, Michelle. Oh, I saw somebody just walk in. Hi. Well, we still haven't heard from
That's
EM. Say
one
it?
of my 11-year-old kids. She's
Oh.
one of my 11-year-old.
Nice. Well, now we've met. Cool. All right, questioner, what do you got for us?
So, have you ever you talked about what to do with a little thumb drive of an audio in a trial?
Thumb drive of an
But-
audio in a trial.
Like if you want to
I don't remember.
make an exhibit. Okay, well you said that
Oh, if you want to make an exhibit. Okay. I can tell you the way I've done it. And it's not with a thumb drive. What we'll do is we'll actually burn a DVD of the clip that we played, whatever that may be, or the excerpts that we played at the depot, give it an exhibit number, and then admit it into evidence. That way it's in your record so that, if the appellate court's going to do something with it, they have the stuff that was actually played to the jury. Secondarily, anything that's going to get played to the jury, at least in lieu of live testimony, the way we do it, there's going to be a court process in advance of that where the other side gets to object. They get to maybe put in some of their own excerpts. You go back and forth. The judge rules on it. And then you file the finalized, approved package of excerpts. So that also becomes part of your appellate record. So you have two things going on there. You have the excerpts themselves that were approved and the motion hearing result, the order approving them. And then you also have the, exhibit, the marked admitted exhibit that is the actual video that you played. I don't remember what the thumb drive was. I think that might have been just
We
how we
were
play.
talking about audio. We were talking about audio. My question was about audio. It wasn't about video. So,
Well, it's gonna be the same method. It's gonna be the same method. You're gonna have the audio transcribed. You're gonna put it on a DVD. You're gonna mark it. And you're gonna admit it.
okay, so here's my question. Since in probate you don't get a trial unless they decide to give you one, even if you ask. And that's been a really helpful way for them to keep all my evidence out. So if I wanted to, I mean, it just seems to me like if there were a car accident and you wanted to show the rusted fender, you could bring in the rusted fender, right? Doesn't matter that it's big and dirty, but if I'm going to stand at the counter trying to file a little thumb drive or a DVD, whatever, like do I make multiple? I mean, I can make multiple copies of the transcript, but do I make multiple copies of the DVD?
Well, you're gonna have to have a copy for opposing counsel, right? You're gonna have to have a copy for the judge, right? And then you're gonna want a copy for your own records.
Okay, of the DVD or thumb drive, whatever it is.
I don't know if they'd even take a thumb drive.
You think they're more likely to take a DVD because it's bigger and harder to lose?
I don't know what the reasoning behind it is, but I haven't had trouble admitting a DVD where I've never actually tried to get a thumb drive admitted.
Okay. Okay.
So that's
All right.
I mean, the DVD is like tried and true technology. Everybody gets it. I think there might be concerns over a thumb drive about, what else is on there. We know that static memory fades over time, so you actually end up losing bits, and ultimately it becomes unreadable. I mean, there's all kinds of issues with thumb drive where just analytically, I would think you're going to have trouble getting that admitted into evidence.
I had no idea what you meant about that technically. Okay, well, sounds like I should get a DVD anyway. Okay.
Yeah.
Okay. All right.
That would be my thinking anyway. All right. Anybody else got anything to kind of wrap it up? We're coming close to about an hour. Sounds like I'm hearing crickets, so maybe not.
Sean, do you know the citation offhand for when there are general legal principles that apply to a situation, but then there's a specific law that the specific law takes precedent?
Not off the top of my head. That's sort of a. Where is it? There's actually. There's something in the CCP legal maxims. Hold on one second. Let's see if we can find it. I've used that before actually in briefing. Maxims, California. Yeah.
You don't think a DVD degrades over time?
I don't think so. I think that it's more stable.
Okay.
Okay, yeah, it's look in code section 35. It's CCP 3509 at SEC, and they have like a whole bunch of legal maxims, and that may be in there.
Okay.
Yeah, there's like a whole bunch of them all the way through, and let's see how far down this goes. All the way through 3548. So that may be in there. If it's not in there, it will almost certainly be, I think, probably in the Appellate Practice Guide. You might look in Rudder Guide, Civil Writs and Appeals.
Well,
All right.
and I had a quick question, just on the children's claims.
Sure.
I understand they're under the Fourth Amendment, not the 14th Amendment, would basically be the equivalent to the adult claims.
It
And then-
depends. It depends if you're talking about a unwarranted seizure claim or an unwarranted medical exam or medical procedure claim. Then yeah, you'd pursue those under the. Well, it depends on the procedure. It'd be for the medical. It's either going to be under the Fourth Amendment or the 14th Amendment, depending on the nature of the medical procedure. For the seizure, it's just going to be under the Fourth Amendment. For the if there is a judicial deception claim, that will also be Fourth Amendment unless it's deception in obtaining a warrant. Then it's going to be Fourth Amendment. Does that make sense?
Okay, so wait, judicial deception will be under 14th unless it includes the warrant, which it would
Well-
then also be fourth.
Yeah, right.
Okay.
Yeah, not necessarily includes if the warrant was obtained by judicial deception.
Right.
It's really a Fourth and a 14th Amendment claim if you look at it analytically, but the way the courts are going to treat it is as a Fourth Amendment claim for the child.
And then what about like a continued deception with reports and stuff? That would be under the 14th?
Yeah, the deception is always going to be 14th. That's a substantive due process, not procedural due process claim.
Okay. And then do you always or typically wait till the children reach age of majority?
No, not always. It just depends on, the parents' appetite once they get the kid back. Appetite for further litigation and our workload. If we're too busy, I won't do the case.
Okay.
Yeah. So sometimes, I can tell you there's the last one I did for the kids, where we resolved the parents' case and then went after the kids. There's probably a 3-year gap, maybe.
Okay, so there's no statute of limitations. Like even if they're not 18, they can bring that.
The child's statute of limitations on their federal claim only. State law claims, it's a different analysis, but for their federal claims only, it's a 2-year statute limit. And this again is California. It's going to depend on what state you're in and what your standard negligence statute of limitations is. But in California, it's 2 years. So the way it works is the child's 1983 claim, the statute doesn't even start to run on it until their 18th birthday. Then when they turn 18, they've got 2 years, meaning that they need to have filed by the time they get to 20 years old.
Okay.
Yeah, so that's.
But they can bring it. But you can bring the 1983 claims before they turn 18.
Oh yeah, of course you can.
Okay.
They can bring that claim whenever.
Well, but they have to have an adult bringing it in their name, correct?
Well, they'll have to have a guardian ad litem appointed, and then they're going to have an attorney because the parent can't represent the child.
Okay. So, and would the federal courts appoint a guardian ad litem for the child if?
Yeah, that's exactly how it works. Is you'll make an application to appoint a guardian ad litem. Court will appoint a guardian ad litem. Excuse me, I've been up since like 4 this morning, and then the attorney will go litigate the claim. So,
Thank you.
Yeah, no problem at all. So before we call it here, anybody have any final questions before we shut this down? All right, I hear crickets. So thank you guys all very much for joining us tonight. I think we had a lot of actually good comments and questions, some pretty interesting discussions, at least from my perspective. I found them interesting. Hope you all did. And I guess we'll see y'all next week. I don't know what James has planned for me, if anything, tonight for the live stream. I know he does have a live stream, but I don't know if I'm on it or not. I'll have to ask him. If I am, I'll see you guys in about half an hour. If not, then I'll probably see you tomorrow night. And with that, you have a wonderful rest of your weekend.